Practicing in the area of consumer bankruptcy law here for about 12 years, so I kind of know a few of the ins and outs of things. And throughout my practice, I've seen a lot of different people come and go through my office, a lot of different social classes. It seems to be a humbling experience for everyone when they come into my office, and it's not an easy decision to make to come and visit me that first time. It's a little bit of an embarrassing situation for a lot of people. In my practice, I like to call people in, make them feel at ease, comfort them. Even when they say I've done everything I can to keep from coming to see you, I like to assure each client that the law is on their side and that that is what it's all about. It's here to help them, and that they shouldn't feel bad about this or embarrassed, or there wouldn't be a whole book of law out there to support this. I make it my main goal for all of my clients to regain their dignity and respect from the process of bankruptcy. And I think that the law allows for that. That treatment's usually well received by my clients. Most folks are at ease by the time they leave my office. It's my goal to watch the people walk out of my door the first time and sigh of relief and say, I think I'll get some sleep tonight. So then I know I've done something good, and the bankruptcy law has done something good. One of the horrible misconceptions I've noticed by a lot of consumers out there is that folks run out and just charge up all their credit cards and run up their consumer debts because they just know they can go right in and file a bankruptcy and get rid of all that debt. That's a bad misconception that I try to correct quickly in any of my friends or anybody off the street who says that. I would like for them to come sit in my office for just one day and watch the folks who come through my office. Nobody wants to come in there. But like I said, I like to make it a good experience for most folks. I start out with a few statistics about bankruptcy. I've given you a little handout with an outline of some of the stuff I'm going to hit on, and maybe you can make a few notes beside it in case Alan gives you a test later. The Consumer Bankruptcy News has recently reported this year, I get a new report at the beginning of every year, that bankruptcy filings were up 9% last year, the year of 2010, from the year of 2009. What that means in numbers is that in 2010 there were 1,530,078 consumer bankruptcies filed in the nation. It was a little under 1.4 million last year, the year before in 2009. Consumer filings have increased since the Bankruptcy Prevention and Consumer Protection Act was enacted in 2005. That brought in a mad rush of filings. That was the last change of the law we had, and after that it's increasingly gone up and up and up each year. We're going to talk more about that BAPSIPA, as we call it, Act, or Bankruptcy Abuse Prevention and Consumer Protection Act, in a little while. Analysts do expect the number to rise in 2011 because, as you guys can probably see, the economy's not getting much better. If you've bought gas lately, you know that. More filers are coming from Middle America. When I first started practicing 12 years ago, let me not make myself too old, seemed like maybe a little bit of the more lower class, but it's now affecting with the economy the way it is a lot more of middle class Americans. The housing and mortgage crisis has just decimated the lives of the middle American. Many of the bankruptcy filings I see are brought on by job loss, medical difficulties. There's a rising increase in living expenses. As I mentioned, the gas, if you bought gas lately, you can see that. A recent report also I saw shows that the average credit card interest rate is 15%. In my book, that's pretty high. If you miss a payment on a card that's got that kind of interest rate, that interest rate is most likely going to double in most of these credit card agreements. And I've actually had a client bring a statement to me because I told her I wanted to see it. A credit card interest rate of 55% on one card. That's just outrageous. So there's nothing sometimes people can do but get into these binds. Businesses have been filing bankruptcy. A lot of major Chapter 11s you've heard about in the last several years. A lot of manufacturing plants shutting down factories and layoffs. The general slowing down of the economy is trickling down to all the consumers, which brings more folks to file the consumer bankruptcies. Tonight I'm going to talk about the consumer bankruptcy, and I'll be focusing on the two forms of that, Chapter 7 bankruptcy and Chapter 13 bankruptcy. I'll give you a little historical background of bankruptcy and where it all came from to start with before I get into those individual chapters in any great detail. The idea, actually, of forgiving of debt, I always like to say, relates back to the Old Testament. In Deuteronomy 15, The scholars have called it the year of canceling debts, and that's specifically in verses 1 and 2, and it says at the end of every 7 years you must cancel debts. This is how it is to be done. Forgiveness of debts is cited again in the New Testament in the Lord's Prayer, where we state, "Forgive us our debts as we forgive our debtors." Moving on to the forefathers, there's a bankruptcy clause in the Constitution allowing the Congress to create a uniform law on bankruptcy. And the first federal bankruptcy law was signed into act in the year 1800. The law is currently in the form of the United States Bankruptcy Code, and a full copy of that code can be found in Title 11 of the United States Code. And you can find a copy of this or a complete copy on the internet. I've put the website in your handout, but it's www.law.cornell.edu/US code /11. It's a real easy to navigate site if you want to go on there and read a little bit of the code yourself or certain sections, and I may mention a few sections tonight, and you can go there, read those full sections on that website. Over the last several years, the code has been reformed several times. Most recently, I mentioned earlier, the Bankruptcy Abuse Prevention and Consumer Protection Act, and that was enacted in 2005. It's presently the newest code that we follow, and it was the most dramatic code to the change in about 25 years. A lot of folks believe that the goal of this act was to make it a lot tougher for consumers to file a Chapter 7 bankruptcy, or what people call a straight bankruptcy, rather than a Chapter 13 bankruptcy, where you pay back some to your creditors, or required to pay back some to your creditors. Chapter 7 and Chapter 13 are the consumer chapters of bankruptcy, and most of the nation's filings fall under those. That 1,500,000 and some odd number I mentioned were all consumer filings last year. Focusing on Chapter 7 bankruptcy to start with, what I say to most folks is my personal quote for that is, this is what most people think of when they think of filing bankruptcy, just getting relief from their debts or getting rid of the debts, getting a fresh start from your creditors. A lot of folks do refer to Chapter 7 as a straight bankruptcy, like I mentioned earlier. That's because you can get a wipeout of all of your unsecured debts, things like credit cards, signature loans, medical bills. That's called a discharge of all of your debts. Some folks come in to see me, and even some folks on the street have a little bit of a misconception about Chapter 7, that you can keep your car or your house and not pay for those items in a Chapter 7. But that's just not the case. Those are some items that you have to pay for because those are called secured creditors. And that brings me to discuss secured debts and how they are handled in a Chapter 7. The secured debts are something that are attached to some form of collateral, like a car, real estate, furniture, boats, other forms of recreational vehicles, in some instances electronics, jewelry, a debt you have something to show for is what I usually say. In a Chapter 7, which is the straight bankruptcy, where you discharge the debt, you must either reaffirm this collateral or it must be surrendered back to the creditor for the debt. To reaffirm that debt means to continue making the payments to that secured creditor under the terms of your original contract with that creditor. I tell my clients, make those payments like you never saw me, so that they know to just keep doing it like clockwork. If you are unable to continue those payments, or you feel that it would be an undue hardship to do so, you can surrender the collateral back to the creditor. You can give them the car back, you can move out of your house and let them have that, you can give them the furniture back, things like that. Once you surrender the items, that debt becomes one of those unsecured debts that can then be discharged in the Chapter 7. So then you wouldn't have to pay for the item if you give it back. In some circumstances, there are additional debts that can be discharged in the Chapter 7, like taxes, if there are certain time limitations from filing on the time limit of filing the taxes, student loans, excuse me, when there are certain hardships. But in order to discharge these debts, you've got to go one step further than just filing the Chapter 7. You've got to file a separate proceeding called an adversary proceeding. You usually file that coincidentally with the Chapter 7 petition. However, the discharge of these debts, like taxes and student loans, are very rare, and you've just got to have those perfect, certain circumstances to do that. So I don't do a lot of the discharging of those debts. I don't see a lot of those get discharged. There are also some exceptions to the Chapter 7 discharge, things that you cannot discharge. If you do go look at the code, these can be found in 11 U.S.C. 523A, and those things include alimony, child support, debt stemming from willful or malicious act, death or personal injury caused by a DUI offense, and debts incurred through fraud. As individual and joint debtors, each filer that files a Chapter 7 is allowed to retain some certain property. You don't necessarily have to give up everything you have just to file a Chapter 7 bankruptcy. There is a federal exemption scheme that tells you how much you are allowed to keep in this certain property, but there's also, each state has their own laws about these exemptions, and a lot of states choose to follow the state law exemptions. Alabama is one of the states that follow those exemptions, and unfortunately we have some of the lowest numbers of property that you can retain and file a bankruptcy and not lose. The real property exemption is $5,000, so you could own a piece of real estate that was worth at minimum $5,000 and keep it, and your creditors could not get to that. With personal property, it's $3,000, so you can have $3,000 of furniture or autos or personal assets that you can protect from your creditors, and the court can't seize those. If you have any assets over and above these certain limitations, they are subject to seizure and sale by the bankruptcy trustee. That generates funds to be paid over to those unsecured creditors that you're trying to discharge. You may not have enough items to go out and sell yourself to pay everyone in full, but a bankruptcy trustee would take those items, get what they could, and then divide up the proceeds between your various creditors so that everybody would get a little bit. Sometimes, though, you do have assets over and above these limitations, and you do want to protect those assets, but you still need that relief of bankruptcy. You still need some help with your creditors. That's when we look at filing a Chapter 13 bankruptcy. Chapter 13 bankruptcy works more like a debt consolidation, basically taking your bills, putting them into a monthly payment plan, and having you make one payment each and every month. In most cases that we file, and in most districts, they do require those payments be done through a payroll deduction, where your employer would take the money from your check each and every payday, just like they do your taxes, and mail that into a trustee of the bankruptcy court, who would then evenly and fairly distribute that to your creditors through your organized plan. When you file a Chapter 13 plan, you're required to include all of your creditors. I always tell folks, just you must file all of your creditors. That's not my rule, that's the law. So that they know it's not me just making you do it. The law requires you do it. You can't pick and choose. The point behind that is you can't pick and choose and preferentially treat one creditor over another. Everyone gets equal treatment. Most of the Chapter 13 plans are 5-year payment plans, or 60 months. Chapter 13s are generally used, we file those to do things like stop repossession, stop foreclosures, and catch up on mortgage payments that someone may be behind on, and to pay those secured debts that can't be discharged in a Chapter 7. You can also pay back taxes, back child support, and student loans through a Chapter 13 plan, whereas you can't discharge those debts in the Chapter 7. As long as you pay those debts in full, taxes, alimony, child support, student loans, through the Chapter 13 plan, you can handle them that way. Dependent upon each debtor's situation, Chapter 13 plans are sometimes filed as what we call pro rata plans, or some places call them pot plans. And what that would mean is that you don't necessarily pay all your unsecured creditors in full. You may just pay them back at a percentage rate or a pro rata amount. And that's effective. That's most of the plans I see here are pro rata or pot plans. Secured creditors, though, like the auto loans I've mentioned, or any like mortgage arrearage if you're behind on your mortgage, furniture debt, things like that. Those are debts that must be paid in full through the Chapter 13 plan. Anything that is secured or anything that is a priority creditor like taxes, child support, back child support, or student loans. Priority and secured creditors must be paid in full. Now in some cases we can get reduced interest rates on those debts, or maybe even we use the terminology cram down the value of those debts to be paid through the plan so that you get a little bit of break on the payment of those debts. A lot of changes. You've heard me mention a couple of times the Bankruptcy Abuse Prevention and Consumer Protection Act, that's a mouthful, of 2005. And because that is the current code, I'd like to mention some of the changes that made, because it was a pretty dramatic change in the law. One big change it made was that all debtors or all filers are required to do something called pre-petition credit counseling in order to file the bankruptcy. This is also done at the debtor's expense. After that, debtor must also have debtor's education or financial management instruction post-petition, after they file their case. The premise behind that is that it would teach them how to not come back and file another bankruptcy, hopefully some management skills. They have to do the post-petition financial management prior to being able to complete their case or receive their discharge, which is the end result of the case. One of the largest changes we saw was Congress enacted a means test. This is a test that all debtors must complete and file with their bankruptcy petition and schedules. It is actually a look back at the income the debtor has received within the past 6 months preceding the filing of the petition. This determines what we call the CMI, or the debtor's current monthly income. Each state has a median income per debtor or family size and household that they must follow. It changes sometimes based on different IRS standards. I put a chart in your handout that just shows you the different states so that you can see who has the highest median income, who has the lowest median income. I think Alabama's at the top, so you can see where we fall. Now, once the eligibility to pay by the debtor in the Chapter 13 is determined by completing this means test. This does include deductions, though, for payments for secured debts and reasonable and necessary expenses. Those reasonable and necessary expenses used on the means test calculation are set by the IRS according to each state and county where the debtor resides. One recent decision we just saw in a bankruptcy court has given some debtors a little relief under that means test, because what has never made sense to me is that if a debtor comes to me and says, you know, I've lost my job, I need to file, but the last 6 months they had a great job, they were making a lot of income. Well, obviously they can't afford to make a payment at the current time based on what they've made for the past 6 months. There was a big Supreme Court decision that gave judges, local judges, some discretion in circumstances like that to overlook the means test and go back to a true budget of the debtors at the current time to determine what they may need to pay to their creditors. If a debtor is above that median income we were talking about for their household size, in most instances they're not eligible to do the Chapter 7 or the straight bankruptcy. They would be required to file the Chapter 13 bankruptcy and pay back some, pro rata, or all in full of their debts. Debtors over the median income are most times required to pay and file a 5-year plan and pay for the full 5 years. One of the other significant changes in the 2005 Act set stricter time limitations on how often you can file a bankruptcy. It actually gets confusing and kind of makes me feel like I'm back in some type of advanced math class when I'm trying to figure out, you filed a Chapter 7 in 2005 and now we want to file a Chapter 13. How many years has it been? I actually put a little chart. I used to try to stand up here and rattle off the details of that, but I put a little chart that's pretty easy to understand in your handout for the time limitations on filing. The biggest thing is that you must now wait 8 years from a previous Chapter 7 discharge in order to file another one. So I'm real careful about advising folks to do that Chapter 7 if they're not ripe for that yet, so that they don't eat up that right for so long.
But now, excuse me, but if they file a Chapter 13, I've got some reports where they file a Chapter 13, I've managed apartments, and then they later, less than a year, they've converted it to a 7. So that is.
And that's possible if you're within those time limitations. Yes, ma'am. If you initially file a Chapter 13, you may later be eligible to convert that Chapter 13 to a Chapter 7 bankruptcy, assuming everything else is in line, the time requirements, the income requirements, things like that. There are several provisions of that bankruptcy code out there that are very, very important to those seeking the protection of the bankruptcy code. One that is the most helpful to most folks who come in to file is the automatic stay, and that is found in 11 U.S.C. 362. This is a stay that goes into effect immediately upon the filing of the petition with the court. It provides immediate relief to the debtors from any collection effort, meaning no one can come repossess the car, nobody can call them to try to collect directly on that debt, no one can foreclose on their home, no one can call them incessantly, no one can try to garnish their wages, no other collection effort outside of what they're handling in the bankruptcy. And that's the biggest relief to most people, is when they can no longer get those phone calls, or they don't have to run from the repo man and things like that. There is one way that a creditor can get around that automatic stay, and the only way to do that is to file a formal motion with the bankruptcy court called a motion for relief from the automatic stay. In order to do that, though, the creditor must have a legal argument to base that upon. You can't just say, I don't want to be a part of this and I'm going to file this motion. They've got to have a legal basis to file and defend that motion. Another important provision of the bankruptcy code, and one of the biggest ones, is the end result of any bankruptcy proceeding. It's what most people are hoping for when they come here, and that is a discharge. That's when you complete your case, whether it be 7 or 13. That's when you can start to rebuild your credit. I always tell my clients that they will receive an actual piece of paper that says discharge of debtor, and they need to hang on to that piece of paper and act like it's a birth certificate, because it is their birth certificate from their bankruptcy. Your future creditors might want to see that to be sure you're discharged. That discharge provision is found at 11 U.S.C. 524, and that basically ends the bankruptcy process and means that the debts you included in your bankruptcy are gone forever. In a lot of instances, that discharge of a bankruptcy does a lot more to repair someone's bad credit than dealing with debt collectors and trying to pay the debt direct themselves over many, many years. I'd like to talk also a little bit about the process of filing a bankruptcy, how it works in the real world. Basically, the process begins with an initial consultation with an attorney or with me. In my office, everyone meets with an attorney on the first visit. I do not have my paralegals meet with an attorney. I think that's very important for most folks, that if you're practicing this, you need to get in there and you need to tell your clients the exact details of everything. On that initial visit, I'll usually evaluate the person's situation and try to go ahead and advise them of whether or not a Chapter 7 would be in their best interest or a Chapter 13 would be in their best interest. Most of the time I work pretty quickly with folks. I like to do that because I want to get that automatic stay into place to give my people that sigh of relief that they're looking for. Usually only takes about 3 or 4 visits into my office, sometimes as quickly as 3 to 5 days to get this process done. With a debtor's cooperation on providing me the correct information, I can work very quickly. Debtors have to provide information about their creditors, detailed information about creditors, about their assets we've mentioned, all their liabilities. They have to produce things like past tax returns for the court to review, pay stub information for the court to review, and any other important documentation about their financial situation. That information is taken and put into the form of their petition and schedules that's filed with the court. About 30 days after we file that petition with the court, the debtor and the debtor's attorney must appear for a hearing that's called a Section 341 meeting of creditors. And you guessed it, that can be found at Section 341 of the Bankruptcy Code. The idea is that it's an opportunity for the creditors to come and ask the debtors questions about their debts or try to work out any issues or problems in a friendly way that there might be. The meetings are usually presided over by the bankruptcy trustee that's been assigned to that case. A trustee is the person who comes in and administrates the case or oversees the administrative proceedings of the case. That is both in a Chapter 7 and a Chapter 13. Presently in our district we have 2 Chapter 7 trustees and 1 Chapter 13 trustee. One thing that I have observed about a lot of people is they wait too long to come and see me for the bankruptcy assistance. That's those people who really need that sigh of relief. I really wish I could get the word out there to a lot of people. Come talk. I personally offer a free consultation. Come talk to me. Find out what it's all about. Everybody's scared to hear about it. But in most instances, people just put it off too long and they let the stress build and get too much, or maybe lose items they could have kept if they'd have just come to see me sooner. We talked a little bit about rebuilding credit in the process, and I put some notes at the bottom of your handout about things I recommend to my clients in order to rebuild their credit after they receive a discharge, they're not ruined for life. A lot of people think, oh, I'll never be able to get any credit again, but that's just not true. Actually, a lot of creditors will extend you credit too fast and furious after a bankruptcy discharge, so I do warn my clients to be very, very careful about what you do. One good way to start out, though, is to start out with one credit card, preferably a secured credit card where you put up a balance that you more or less borrow back against until it's gone. Recommend making timely payments on that credit card. Pay the balance off each month. If you have to hide it in a drawer at home and only take it out once a month and spend a little something on it, rebuild that good payment history. Another thing is to seek lower interest rates. Don't take a loan or a credit card or a mortgage from the first person who offers you one. Shop around. If you rebuild that good payment history, call that creditor, say, my interest rate started at 18%. I've made payments for a year on time, every month, paid in full. Please reduce my interest rate. Most of them will do that. Be careful and leery of credit repair schemes. There's a lot of those out there, and they ask for a lot of your money up front, and then they don't help you. Control those balances on anything you do. Maybe start out with an automobile purchase before you jump into a mortgage. I've also enclosed a little article in your handout called The Case for Walking Away. That's a really good article, and my take on it is the opinion of the writer wasn't too much of a fan about bankruptcy until she learned a little more about it, learned a little bit more of what we've just talked about tonight, and that it's not as bad of a process as a lot of people think. That's all I have for you. Thanks.
Thank you so much. All right.